All right, well, our next case is Doyle versus St. Clair. Each party will have 15 minutes to present their argument. Counsel, do you know how long you'd like to reserve for rebuttal?
5 minutes.
All right, very good. We'll note that. I'll be keeping track of the time up here, so when I get to 1 minute left in your initial time, I'll give you a sign that there's 1 minute left, so you know that if you're proceeding.
Thank you.
If you want to proceed after that, that's fine. We'll just take that time off your rebuttal. So if you
Okay.
need to keep going, that's up to you.
That's fine, thank you.
The arguments are being recorded, so when you come to the podium and ready to start, please introduce yourself. Please stay behind the podium because it's being visually recorded as well, and if you walk away from the podium, we'll lose you for a second.
Okay.
Please speak loud enough so that we can hear you. I don't think in this case we have any children, minors, or victims to refer to where we're referring to, but if you were, please make sure you use their initials or some other designation rather than their name. And with that, we've read your brief and ready to proceed whenever you are.
Thank you. The divorce decree was from February of 2009. Part of that decree was that Mr. St. Clair, the husband, was going to take sole responsibility for a number of Huntington Bank loans, including one for the Steingles, and that's the one that's pertinent to this case. The Steingles were Joann Doyle's daughter and her husband. Now, both Ms. Doyle and Mr. Sinclair were co-makers on that loan, so it wasn't just that he was taking the loan out of the goodness of his heart. So he was to pay the Steingle loans. There was also a property division of $165,000 that Mr. St. Clair was to pay to Ms. Doyle at $1,250 a month over a number of months. Shortly after the divorce, I guess there were some issues with the Steingles regularly paying on the loan, on their loan, and Mr. St. Clair started to unilaterally deduct payments he stated that he was making on that loan from the payments that he was obligated to make to Ms. Doyle for the property division for the $165,000. Excuse me. As early as February of 2010, Ms. Doyle's attorney at the time, my old partner, Jim Deary, had sent notice to opposing counsel that that was not acceptable to Ms. Doyle, that this deduction arrangement was not agreeable to her. There were a number of letters sent back and forth over the next almost 2 years about that issue, reiterating that Ms. Doyle was not in agreement with any payments on the Stein loans being deducted from the property division. Mr. St. Clair did not take, at the hearing finally there was a motion to show cause that was filed in 2014. There was finally a hearing in 2021, I believe, and at that hearing, there was no evidence actually presented that Mr. St. Clair had in fact made payments on the Stein loan, but we don't dispute that we believe that the loan was paid. Fact is that as Ms. Doyle testified at the hearing and also submitted in sworn affidavits presented to the court prior to all that, she had never agreed to Mr. St. Clair deducting any kind of payments for the loan from the property division payments. The basis for the agreement was that he was to take the loans, and she was very clear about that. As far as the property division, the trial court found that this was really a quantum Merowith application of quantum Merowith. Mr. St. Clair had testified that he had done a whole bunch of repairs to the building, one of the buildings that Ms. Doyle had received as part of the property division. He presented really no evidence to show what his costs were in making those repairs. His testimony was also that he had never talked to Joann about charging her for it, that there was never any discussion about the costs. He never presented her with any invoices, never presented her with any bills, never really had any discussion And as Ms. Doyle testified, the only thing that he had told her was, he'll take care of it. Then, once the show cause was filed in 2014, then Mr. St. Clair says, oh, well, you know, I'm entitled to set-offs and things like that. Problem is at the hearing, there was just nothing there that really showed that, A, there was any kind of an agreement as to, you know, what it was that was supposed to be getting set off. There was never any amounts that were discussed or disclosed to Ms. Doyle as to what was supposed to be getting set off. And there was, I mean, there was just nothing there. Was Ms. Doyle aware that there was construction going on at this building? Yes, she was, but again, she was under the impression that he was just taking care of it because that's what he told her. So there really wasn't anything there to say that, hey, you know, she was getting a benefit, which there was some benefit, yes, you know, there was some construction that was done, but she had no idea what it was. He provided her with no information, he provided the court with no information really, as to what it was that was being done, what he was fixing, and what he was paying.
Counsel, I have a question.
Yes.
When you're talking about the show cause, so the show cause was initially filed in 2014, and that's when he brought up all the issues in regard to him making the payments and repairing the building and all those type of things. Well, that was affirmed on appeal in 2016, right?
I'm sorry.
The ruling there was affirmed on appeal in 2016.
Yes, I believe it was, or I think it was the dismissal of the show cause, if I remember correctly. And, yeah, but then once the 60B was dismissed on appeal, then the trial court reopened the show cause matter because everything had pretty much gone away as a result of the dismissal. That was my understanding. I believe that was the court's understanding as well, the trial court's understanding.
So we don't have a problem with res judicata or law of the case or anything?
I don't believe so. No. The other thing, as far as the building was concerned, you know, as I said, Mr. St. Clair came in and testified that he'd spent $70,000 to repair it, but there was nothing to show what it was that he did. He didn't even produce any kind of, really any kind of documentation to establish what it was that he had done, or how much he had paid for it, or how much he was out of pocket for it. And as I said, he never discussed this with Ms. Doyle, never admitted under oath that he had never given her any kind of a bill or invoice or anything like that. He also testified that he never had received any kind of indication from Ms. Doyle that she had agreed to this offset that he was doing with the $165,000. So he did state that he sued the Steindls, and then he also sued the insurance company. He got $1,800 from the Steindls, got $29,000 from the insurance company, but there's nothing to indicate that he ever attempted to recoup any kind of monetary losses or anything like that, or any kind of debt from Ms. Doyle. So he had ample amount of time, if he believed that he was owed money, to recover that in other matters, or in another manner. You know, doing it this way, the court is essentially, trial courts essentially said, well, you know, even if you're owed something for other work that you've done that's not necessarily directly related to the divorce, you can now always use your divorce decree to come back and you know, try and recoup money if you don't feel like doing it some other way. You know, in this case, quantum Merowit's got a 4-year statute of limitations. We were well past that by the time Mr. Mr. St. Clair had filed his motion on.
1 minute left in the initial time comes.
I'm sorry?
1 minute left in your initial
Thank
time.
you. So, in short, to sum up, believe that the trial court erred in granting relief to Mr. St. Clair by giving him credit for unfounded allegations as to what it was that he had done for the particular building in question, as well as for unilaterally deducting any payments he may have made on the standalone against the property division. So, thank you.
Good morning. Anthony Giardini, I'm here as the attorney for the Appleby. And 15 minutes, is that correct, John?
Pardon me, you got 15 minutes.
Thank you. I have a completely different view of what occurred in the trial court and what the decision of the trial court was and the issues that are central to this case. The Steiner loan was not central to this case. What is central to this case are two things. One, the separation agreement called for the two-party, for Mr. Doyle, my client, or Mr. St. Clair, my client, paid to Ms. Doyle $165,000 over 10 years at the rate of $1,250 per month. We called it a property division equalization payment. But the trial court didn't change that one item, it didn't modify that term at all. But the trial court found, and there was ample evidence, including both stipulated evidence and admissions by Ms. Doyle, is that Mr. St. Clair did in fact pay all or perhaps even more than the $165,000 in value. First, the parties agreed that actual cash payments of $100,400 and some odd dollars were made by Mr. St. Clair to Ms. Doyle over the period of time after the divorce. The other part of this case that is central to the issue of, and we're here on an appeal of a denial of a motion to show cause. The other issue that's central to this is whether or not, in determining whether or not Mr. St. Clair violated the court order, whether or not he provided Ms. Doyle with her consent value that exceeded that $165,000. $100,000 cash, there's no dispute. The dispute is over $65,000 in non-cash direct payments to her. And here, the evidence is undisputed. 3 months after the parties were divorced, so in May of 2009, at a period of time when Ms. Doyle had been awarded a commercial building located on North Ridge Road in Amherst, a large 10,000 square foot commercial building. She was responsible for and was collecting the rents from that building. She was responsible to pay the insurance, she was responsible to pay the taxes, and whatever utilities went along with that. Ms. Doyle allowed the insurance policy on her building to lapse. Now, that building had a mortgage on it that we agreed Mr. St. Clair was obligated to pay. So in other words, he had to pay off the mortgage on the building that she was awarded by agreement. And he did. The problem is when the insurance policy on her building lapsed because she didn't make the premium payments, the bank forced insurance on the property. Well, when a bank does that, in this case it was Lorain National Bank, they forced insurance to protect their mortgage loan. Not to protect her or the building, but to protect their mortgage loan. So as a consequence, the day after the fire in May of 2009, Ms. Doyle was sitting there with a badly damaged building. The entire tenant space on the 4,000 square foot tenant space was burned out. Smoke damage had gone through the rest of the building. On that day when she, by admission, met with Mr. St. Clair, who, by the way, is a contractor. She met with Jack at the building, and she knew that she didn't have the money to pay for the repairs that needed to be made. And at that meeting, Mr. St. Clair testified unequivocally that he told her, I'll come in with my contracting company and make the repairs. I know you don't have the money to pay me now or pay it up front. I will deduct it from the money I still owe you on the equalization payments. And at that point in time, he still owed her over $160,000. It was just 4 months into the divorce. She admits that they had the conversation. She admits that she was there with him at the building, and she admits that he said he would take care of it. She can't remember whether or not how she agreed to pay for it or how they would do it. Well, obviously, in May of 2009, when they made the agreement, nobody had any idea how much it was going to cost to repair the building. Mr. St. Clair testified that he replaced the furnace, rewired, fixed the security system, replaced carpeting, painted the inside, had to deal with all this smoke damage. He just jumped in and started doing the work. Now keep in mind, this is in May of 2009. These repairs went on all of 2009 and actually for part of 2010. During that period of time, Ms. Doyle's own records show that Mr. St. Clair stopped making the equalization payment. So from May of 2009 until at least June of 2010, period of 13 months, he made no equalization payments whatsoever. In April of 2011, Ms. Doyle files a motion to show cause against Mr. St. Clair and doesn't complain about the fact that she hasn't received equalization payments for nearly 13 months. Doesn't even mention it. She raised one issue in her motion to show cause. You didn't deed certain properties that I was supposed to get and was awarded in the divorce decree. You didn't actually sign the deeds over to me. And when Mr. St. Clair signed those deeds, then she withdrew the 2011 motion. At no time did she mention anything to the court about, and by the way, I'm owed, at that point in time, what would have been well over $20,000 in equalization payments. She didn't, we submit, because she had already agreed that these payments would not be made, that he would deduct what he was paying on her behalf to fix her building, which was uninsured. And he testified, and by the way, Your Honor, that Mr. St. Clair also paid for and filed a lawsuit on behalf of himself and Ms. Doyle against the insurance company, against the tenant who they believed caused the fire to begin with, and one other party, in an attempt to collect back some of the money that was being expended by him on behalf of Ms. Doyle. When he testified that eventually the insurance company that the bank put in place, and by the way, because Mr. St. Clair was the obligor on the mortgage and had agreed to pay it, the bank, when they wanted their insurance premium for the policy that they put in place, they took it out of Mr. St. Clair's checking account. And Mr. St. Clair testified to that. So Mr. St. Clair paid the insurance premium to the bank, that the bank charged him for her building. But that money went directly to the bank. So in effect, when the trial court found that Mr. St. Clair recovered $29,000, he testified that money went directly to the bank. He paid the premium for that those insurance proceeds to be paid toward the mortgage loan that he was personally obligated on. He didn't pay that premium on behalf of Ms. Doyle or her building. He paid it on behalf of himself, which the bank charged him automatically by taking it out of his checking account. So by 2014, when the second motion to show cause was filed, and the first time that any of these reduced payments or no payments was raised by Ms. Doyle, first time, 5 years after the divorce, 4 years after the work had been done. Then, of course, Mr. St. Clair says, whoa, we already had an agreement on this. And to the extent that she disputes that agreement, because she doesn't recall exactly, her actions speak far louder than her memory. Her actions were to not do anything to raise the issue until 4 years after the fact. So her building is now repaired, the tenant's back in business, everything is done. The only problem is Mr. St. Clair's out $73,200 that he expended on her behalf. And the notion that she had no idea what it was, maybe in May of 2009, when the two of them met after the fire, none of them knew exactly what it was going to be. We'll accept that. But to say that she didn't understand that all these repairs were being made to her building that she was at, seeing furnaces replaced, carpeting replaced, painting done, electrical work done, it just challenges her credibility. The fact is that what the court found was irrelevant to the Steiner loans. He does talk about, the magistrate does talk about it, but if you look carefully at his decision, he didn't give it credit for that. What he said was, I find from the evidence that Mr. St. Clair made $73,200 worth of repairs to your building, Ms. Doyle. That coupled with the $100,000 that you agreed he paid in cash gives you more than the $165,000 equalization payment. That's what she bargained for. Now, the appellant raises the issue of 3105.171I. That statute, which we don't dispute, says that a court cannot modify the terms of an agreement like this without the express written consent of the parties. That didn't happen here. The court did not modify anything. What the parties did, and specifically what Ms. Doyle did, was agree to change how she would get her $165,000. That's what happened here. That's what the court found. And if you look at the Supreme Court case, the one Supreme Court case cited by appellant with regard to 3105.171, you will see that the Supreme Court says that the trial court had, in that case, unilaterally changed a date of marriage, which changed the term of the marriage, which then changed how much pension one of the parties got from the other party. So the court unilaterally did something, and neither of the parties had consented to it. In this particular case, our court here, dealing with, not a motion to modify, but dealing with a motion to show cause, found that the two parties themselves had made these agreements, had done these things. And the court, when it mentioned the idea of quantum merit, it wasn't because the court was saying that there was a claim of quantum merit. If you look at the court's actual language, it says this is similar to, or it's like quantum merit. Namely, Ms. Doyle, you received a benefit at the expense of Mr. St. Clair. You can't keep the benefit and then ask for money that he owes you under your contract and effectively collect twice. That's what the court was saying. This court has determined in cases as recently as 2022 that you won't reverse a trial court in a show cause motion hearing unless there's an abuse of discretion. Abuse of discretion means that the decision of the court was unreasonable, unconscionable, or arbitrary. In this particular case, the magistrate who heard the parties testify in person saw what the records that had ample evidence to make the findings.
One minute left.
Thank you, Your Honor. make the findings that he made. To sum it up, the trial court did really what the parties themselves had agreed to. Trial court wasn't involved in any of these changes, the parties were. All the trial court said to Ms. Doyle is, I'm not going to find Mr. St. Clair in contempt of this order when you yourself agreed to the very things that he then used as his reason. That's what a show cause is. Show the court why you shouldn't be held in contempt. He did that. Thank you very much.
Thank you.
As I stated before, testimony from Ms. Doyle, affidavit submitted by Ms. Doyle indicate that there was never any agreement or discussion about how much or what, if any, credits were going to be given to Mr. St. Clair for any work done on the building. We're not disputing that he did work on the building. He did, obviously. But at the same time, during the time he was doing work on the building, he was still the title owner of the building because he was still not issued a quick or signed a quick claim deed for that property until sometime in 2011. But more importantly, I think it's very telling the fact that if Mr. Doyle, as he claims, had some agreement with, or Mr. St. Clair had some agreement with Ms. Doyle, as he claims, for offsets, he never produced any kind of bills or invoices to her. You would think that if you're looking at $100,000 that you owe your ex-spouse or anybody, and you have some sort of an agreement that, hey, whatever work I do in this building is going to get credited to me over here for the property division, that you would submit at least some sort of bill, you would submit some sort of an invoice, something, to Ms. Doyle saying, hey, look, here's what I've done, here's the value of my services, this is what should be deducted from my property division, or from the standalones, or what have you. He never did that, never did that. Even at the hearing, he really never did that either. He never produced anything to show what his actual costs were for doing this. And as far as Ms. Doyle knew, he was just doing it to do it. There was never any discussion from her testimony that she agreed to any of this.
Except that it cuts both ways, doesn't it? Because she also was not getting full payment.
In terms of the 165?
Well, no, as the payment equalization payment.
Correct.
And so for 9 years, she didn't say anything.
Well, no, there were letters from 2010 through 2011 between council clearly saying that, hey, you know, these deductions, for at least for the payments for the standalones, were unacceptable. But
But you filed a motion for contempt, you would agree, in 2011 or
Yes.
so, and doesn't raise that issue, just raise the issue of property.
she did not. As she testified, that was a decision that she made with her counsel at the time to pursue the title issue first and then deal with whatever else they had later on. So I was not privy to those discussions, so, but that was apparently a decision that she had made with counsel. But, you know, in order for there to be an agreement, there needs to be an agreement, there needs to be terms. And there were no terms, because nobody, as Mr. Giardini stated, in '09 there was no understanding as to what the cost of the repairs were going to be. But after that time, Mr. St. Clair would have known, or should have known, what it was he was laying out to fix this property, yet he never provided any of that to Ms. Doyle. So it's kind of hard to say, well, you know, he's entitled to this offset, when it didn't seem like he was really making any effort to let her know what it was that was being offset, or how much was being offset. So as far as how this relates back to the show cause is, I believe it was an abuse of discretion for the court to say, hey, you know what, he's paid on these other issues, so therefore he's good on the property division, when there was nothing submitted showing what exactly it was, other than his testimony that he could recall, what it was that he had actually laid out, what his costs were to repair this building. So I think by saying, oh, well, you know, in his mind, he thought that he had complied with the court's order, despite the fact that he never provided any kind of evidence or any kind of document showing what he was actually paying out, and what he, if he had been entitled to a credit, what he would be credited for. To say then that, you know, he gets to go scot-free and he was not in contempt because that's what he believed, I don't think that that's sufficient. You know, it can't be discounted what my client testified to, that there was no discussion about what it was that this was going to cost him. And she never agreed to any kind of offsets for anything. So I think that it was an abuse of discretion in terms of denying the motion to show cause on the basis that he had already somehow paid her for services that he never really, he told her about what he was doing, but he never gave her any indication that he was going to charge her, or what he was going to charge her, or how much he actually spent on the program. So for that, we ask that the court reverse and remand this for further proceedings.
Thank you.
Thank you.
The court will take the matter under advisement and will issue a decision in due course. With that decision agreed, it will be mailed to you by the clerk of courts. It'll also be available on the High Supreme Court website.
Okay.
With that, on behalf of the court, I'd like to thank both of you for your presentations.
Thank you much.